All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmera, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us here today for Student Loan Essentials, Updates, Strategies, and Advocacy for Legal Aid Practitioners. Before I introduce our speaker, I do want to go through some quick housekeeping announcements. This training is being recorded. You're going to receive a copy of this recording in an email from Zoom within 24 hours. If you don't see that email, I'm still going to drop my contact information into the chat just in case. Feel free to reach out to me for anything that you may need there. The training was approved by the Florida Bar for 1 General CLE Credit. I'll announce the CLE code towards the end of the session. If for whatever reason I forget, no worries. I'll also drop the code into the chat. It will also be included in the email that will go out from Zoom. Closed captions are enabled for anybody who needs them. If you're having issues with accessibility or captions, you can reach out to me directly. A major reminder, this webinar is being co-hosted by the Public Interest Law section of the Florida Bar, or PILS. If you're not familiar with PILS, I highly encourage you to take a look at their website. We have multiple work groups and substantive area committees where we have great discussions and we come up with ideas like this training. And final piece of housekeeping announcements, Q&A. We do have the Q&A feature. You can drop your questions into the Q&A box. If the question is related to the slide, we'll try to address it at the moment, but we will try to get to all your questions towards the end at the very least. So without further ado, it is my pleasure to introduce our speaker today, Christie Arkovich, a Florida attorney for over 25 years, graduated with honors from Stetson College of Law in '92. After working in commercial litigation, she established her own practice in 1995. Dedicated to staying at the forefront of legal developments, she has trained with top consumer rights experts and attended specialized programs on bankruptcy and student loans. An active member of multiple legal associations, Christie frequently speaks at CLE seminars and authors the student loan sidebar column for the Tampa Bay Bankruptcy Bar Association. A former trial counsel for student loan services, she now focuses on consumer advocacy. And another plug, I'm going to drop the YouTube channel, the blog, and her website here. I would definitely encourage you to subscribe to her YouTube channel, follow her blog. There's a lot of great blog articles in there and some really great videos. So I'll drop all of those links into the chat, and I will also include all of those links to those resources in the email from Zoom. Also, let's see if that's the last item that I have. Oh, the materials, the slides. I know I always get this question. I will make sure to include the link to there's going to be a link to a shared folder for the materials. These slides are already there. So without further ado, Christie, the floor is yours.
Thank you very much. Thank you very much. I appreciate it. I'm glad that everyone has taken a little bit of time out of their day today, or if you're watching this later on demand. There's been a lot of changes with student loans this year. And so I really wanted to have everyone be cognizant of things could change in a day, a week, an hour even. I read something new this morning, for instance. And so we do try to keep our blog fairly up to date, the same with our YouTube channel. And so it's important to take a look at that if you're doing any of the student loan work for yourself or for your clients and so forth. So what I'm here to talk about today is obviously the links and so forth to our YouTube channel and our blog there. This reminds me, I need to do a new cram down. I got to figure out what to say because right now things are just all over the place. But when we have a client that first comes into our office with student loans, I always like to start out with making sure that you understand what they have, and don't necessarily just take your client's word for it, because a lot of times they don't know. They know they have a student loan. They know they have 5 or 10 student loans. They don't know if they're private, if they're federal, if anyone else is responsible for them, a co-borrower, or maybe a Parent Plus loan where the parent or the grandparent's responsible. It is kind of messy. In fact, we've had people that come in back when I had went to school. A lot of times you were on a 10-year repayment plan. Well, somewhere, somehow that shifted to 20 and 30 years. And I don't know if anybody really explained that to a lot of borrowers. And so we have folks coming in that think they're almost done with their term. And in fact, their loans are much bigger than what they had even borrowed because maybe they've been on income driven or some kind of forbearances during low income time periods. And they haven't made much of a dent, and they have a 20 or 30-year repayment term and not 10. So they think their loan is almost done for, and in fact, they've hardly even begun. So one of the first things we do is we have them pull their National Student Loan Database report. There is no private one. So with private loans, we encourage them to check their credit. Usually the loans will appear there, correspondence, phone calls. They may have some records themselves, but try to piece together private. There is no database for private loans. But for federal loans, fortunately, there's a database that's online. It's free to get to. People can easily see what loan types they have. Right now, it's better than it used to be. It used to be that we had two federal loan types. One was Federal Family Education Loans, and the other was direct. And before 2010, you had 80% were the older loans, the FFEL loans instead of direct. It made a big difference because many times the FFEL loans are not eligible for things. Public service, for instance, you have to have a direct loan. So you have to consolidate to be a direct loan. And we had older FFEL consolidation loans because before 2010, if you consolidated half the time or more than half the time, you were placed in a FFEL consolidation, which was not eligible for public service. So there's those disparities. During COVID, we found that a lot of servicers were telling people, oh, you have a private loan. You're not eligible for the CARES Act and some of the things that were offered as part of that, 0% interest, zero payments and things. Or maybe we're doing it for a short time, but we're not doing it for years like it turned out to be under the CARES Act. And so we had people that were in default on some of their loans, delinquent on others, current on others. So you had mixed bags of how they were repaying. And servicers weren't helping because they were telling people, hey, you have a private loan. And if it is a FFEL loan, that means that they have a federal loan. It just happens to be privately originated and maybe privately held, but it really is a federal loan. And so they can easily consolidate to a direct loan and be eligible for all kinds of stuff. And even their FFEL loan is also eligible for some things as well. But the servicers, unfortunately, were not communicative with that information, or the borrowers did not hear it. Maybe it was told to them, but they didn't understand it. It's really hard to say. So the first thing we do is we figure out what they've got, what kind of loans, what they're eligible for, and so forth. As an advocate, I think it's important to not only push paper from one side of the desk to the other, but really try to figure out how you can help that person, how you can solve their problem, get a solution, change their loan type so they're eligible for more, do something other than just the basics. And so a lot of times we had a servicer, for instance, that would say, here's your payment under the plan you're on, not bothering to go through with a potential borrower or with a borrower as to how they could better themselves in terms of what their payments are or the forgiveness opportunities that were out there. So we take advantage of that. Now, right now, I guess probably a lot of you are here because of all the things that are coming out about dismantling the Department of Education, what we can expect going forward, how this will affect your loans and those of your clients. And so first of all, there has not been any executive order dismantling ED. What there have been is conversations where the new Secretary of Education, presuming that she is confirmed, Linda McMahon, is basically supposedly to be put into place to ultimately disband the Department of Ed or greatly reduce its job, essentially. And so we think that a lot of things that are going to happen is some of the functions of the Department of Ed are going to be moved to maybe other federal or national agencies or state agencies or discontinued. And the funding by Ed is expected to diminish over time to compensate for the lower responsibilities. Right now, the Department of Education is in fact the nation's largest bank. Wasn't really meant to be, doesn't have a lot of staff. Even before some of the cutbacks here that are happening now. And it's not really equipped to be the largest bank. And when direct loans, they existed before 2010, but when I talk about 2010, that was when the FFEL program was discontinued. And all the federal loans from that point forward that were originated from that point forward became direct loans. Any consolidations of federal loans became a direct consolidation because the FFEL program was no longer in place after, I think it was July of 2010. So you had the federal government basically originating a lot of loans that previously were originated by private lenders. And it wasn't really ever meant to be that way. And I think that it's going to go back to the states maybe taking more of a responsibility there, perhaps private lenders as well. We have had a number of folks who have higher incomes that have actually wanted to privatize their loan, refinance it out of the federal sphere into the private world. That worked really well when interest rates were 2 and 3% for that. But now, the national average on student loans, on federal student loans, is 6.9. It's even higher for private loans due to the interest increases over the years, as well as back in '05 and '06, you had a lot of loans that were originated privately that had very high interest rates. So typically there was that window, and we had a lot of folks take advantage of that window to get 2 and 3 and 4% loans. But now, unless you get that, I still think walking away from the federal world of student loans may not be the best thing to do, because it's hard to say on what's going to happen with some of this stuff. We are still seeing forgiveness in many opportunities. We're seeing tax-free forgiveness. And so we'll go through some of the things that are working and so forth. But essentially, with respect to figuring out what the Department of Ed will still handle, some of these things are laws, and it starts out where the secretary shall do whatever. Those things are still going to be handled within the Department of Ed. They're mandatory, congressionally passed. They have to. IBR is a law. Public service, loan forgiveness is a law. Those things aren't going anywhere, although we are seeing some pushback here and there against both of those things. I'll go through a little bit of that here. For anyone who comes to you that has already received forgiveness, we don't think anything's going to change with that. It's very hard to unravel forgiveness that's already occurred. There's a lot of reliance arguments and other things that legally would make that prohibitive. So we think that these things are going to apply from this point forward. A lot of folks in the past couple of years have been placed on SAVE. SAVE is a very favorable to the borrower income-driven plan. It caused a lot of interest rate subsidies to increase. The interest themselves is always the same. That's one question a lot of borrowers always ask is, can I reduce my interest rates? For those of you who don't know, federal loans kind of are a little different than a lot of loans. So they don't negotiate interest rates. There's no statute of limitations for federal loans. I think one of the fixes for student loans going forward could possibly be something like a 3% rate, maybe non-compounding interest. The biggest problem that we have from borrowers who come to us with help for their loans, many of them can actually pay the principal back. What they can't do is pay the excessiveness that has accumulated on those loans through years or even decades of forbearances, deferments, or not knowing what kind of plan to be in and so forth. So, if we had a lower interest rate and we didn't have a lot of that craziness, maybe a lower, like 3% across the board, would be simple. It would eliminate the political friction caused by forgiveness, and you would have maybe the ability to repay a loan and not get in so much trouble a little easier. But we don't think SAVE, where the Biden administration was trying to put everyone onto SAVE. Currently, everyone is on a SAVE forbearance if they were part of that program. That was all placed on a stay or injunction in June, July of over the summer. And just recently, that injunction was expanded by the Eighth Circuit. So it's still pending. We're probably not going to know or have an outcome until May. We thought maybe it'd be a little bit earlier, but we don't think so now. And so we, when I say we, a lot of the other student loan attorneys and advocates in this area, I think all of us have a shared opinion that SAVE is not going to survive some of the legal or administrative efforts to end SAVE. So we don't think SAVE is going to survive. So what will SAVE become? Well, SAVE was basically an amendment of repay. If you don't know, you have income-driven plans. Think of it as an umbrella over all the different acronyms and different income-driven plans. You had ISR was the first one, IBR 2009. Then you had a lot of things that came after that. You had ICR, pay, repay, and some things like that. IBR for new borrowers and so forth. You may even have a new Republican bill. We don't know the name of it, but I understand it's percolating out there, where it may be based more on how much is repaid, principal plus 10 years of interest, as opposed to the length of time that it took for someone to repay that. So you may have a change of thinking. But right now, with this Eighth Circuit expanding the injunction, they did that on Friday, so just a couple, 3 days ago. And there's a couple key things out of that. One is that the forgiveness that was currently occurring under pay and ICR has stopped. And so if you have someone or yourself, you're almost to the end of your income-driven plan period. Just know that if this injunction is in place, the only plan right now to get forgiveness is under IBR. And my understanding is that as of Friday, the income-driven button on the online system was grayed out, as well as the consolidation button, so you couldn't do them online, but you could still submit a paper application. Now, we had a client who did so yesterday. We'll wait and see what happens with that. But essentially, what I was looking at through a listserv for national student loan attorneys, someone who's very keyed in commented that the forms area with the Department of Ed's website no longer has a paper application for IDR, for income-driven plan. And so that's interesting because we're also hearing at the same time that certification of incomes has been pushed back from December of 2025 to sometime next year. Now, I was thinking the opposite would occur. I was guessing that we would start to see requirements to update someone's income basically shortly after April 15, maybe as soon as May 15 or so. Because when April 15 rolls around, even though someone can extend their tax return, they still have to pay the taxes due. So they still kind of have to know what the income and expenses and things are. And so it seems appropriate that there would be enough information available that someone could then certify their income. So I was guessing that we would have a certification date moved from maybe December of this year forward to maybe May or June. But instead it's being moved the other direction. And I don't really know why that is, except that perhaps these income-driven plans are going to be pushed to a state level, and there needs to be time for each state to try to figure out, how they're going to do that certification. With income-driven plans, that umbrella over all the different income-driven plans, you basically have to have someone certify what their income is using a tax return or pay stubs or what have you. And we've had pauses on that for years now. So there are people out there making a student loan payment based on the income that was previously reported in 2019 because they've not been required to update since. And who knows what their income could be. It could be a lot higher, a lot lower. So that is one of the issues, is when is certification required? When we counsel a client, we go through, well, will consolidation help you? Will it hurt you? What's the risk? Are you potentially going to lose any credits that you might have obtained under IDR if you consolidate now to a different loan? There was an IDR recount that allowed for you to look into the past history. I'll get to that here in a second. But that program has also been stayed. So it's now very risky to consolidate. But public service loan forgiveness, I know, unfortunately, a lot of folks are probably here for that. And I have very little input or knowledge as to what's going to go on with public service loan forgiveness. What we have heard, pretty much without a doubt, is that the payback provisions are no longer working. What that means is that if you're trying to buy months back, where you hadn't made a payment, now you want to make a payment based on a prior income, so forth, you cannot do that any longer, or at least not right now. But we don't know if public service is going to continue within the Department of Ed, a different agency, or within the state. What we do know is it was congressionally passed. So it's a law. Unless Congress passes a different law that says no, it should be there. So, take that for what it's worth, but we just don't know. We'll probably do a future seminar just on public service. Right now, we don't know enough to do that. But hopefully within a month or so, we will. The IDR audit, I'm going to talk about here in a second, that was stayed as of Friday, just recent here. A lot of people have already received the benefit of that, but we are very concerned about those who have loans that are still pending. In other words, they've gotten additional credit for those loans as if they've been making payments under the income-driven analysis, but they haven't yet reached that 20 and 25 years. We don't know what's going to happen with those, and we're watching for that. Borrower defense applications, I think that those could be good for someone who's trying to buy some time. It's like a lengthy application, 10, 20 pages long. It is free. Someone can file directly with the Department of Ed. But we don't expect any resolution on the ones that haven't already been included within the prior class action settlement. And those would have been ones that were filed back in, I think it was June of 2022 or 2021, one of those years, there was a cutoff date. And anyone who filed before that, if they went to a school, there was over 100 or so that were listed as potentially fraudulent schools or schools that have exceeded some of the requirements and so forth. Basically, if you had filed an application before that, your school was listed, the class action required a discharge by a certain date. Many folks were waiting for that date. It came and went January of last year, but those discharges are still occurring. Anyone who filed an application, though, after that date, we don't know what's going to happen. I suspect it's going to be held for quite some time, perhaps denied. The most you can probably hope for is a placeholder while something else goes on. I think I covered a good deal of this already. Double consolidation, basically, that's still valid, but we don't know whether or not it's going to work. And I'll go through the rules here in just a moment. This is just sort of an overview on some of the things that we're going to cover. The bankruptcy process, there was a provision within our bankruptcy laws that allowed for someone to file for discharge of federal student loans. And that process is still in place. It was actually begun under President Trump in his first term, but my understanding is now it has been put on pause. Essentially, it's a program whereby someone can file an adversary proceeding arguing an undue hardship. They then can fill out a fairly lengthy attestation form, send that to the Department of Ed. It doesn't get filed with the case, but send it to the Department of Ed. It's reviewed then, and in conjunction with the Department of Justice, they would enter a recommendation as to whether a full or partial discharge would be warranted, and then it would be sent to the judge. The judge doesn't necessarily have to agree, but many times he or she would. And so that program was getting legs in the last few months. There were quite a number of discharges, about 85% or so of the loans, I think, in that program were being discharged. At the moment, it's paused. The same with the IDR that's in bankruptcy. What that essentially is if someone files bankruptcy, under the old rules, the Department of Ed would automatically place the loans in forbearance. This basically administrative rule change after the Biden administration allowed for someone to automatically get IDR credit for their plan payments as opposed to that forbearance. So in other words, if someone's making a plan payment, they'll get credit outside of bankruptcy for the ultimate 20 or 25 years forgiveness. That also has been paused. We have high hope for that program because I think that if a lot of folks are not eligible for income-driven plan, if we don't have income-driven plans, or if the income-driven plan is too high, like for instance, we have ICR or this newer one, the bankruptcy IDR would be perfect, but we don't know what's going to happen with that. But the nice thing is determined by a plan payment being made, not necessarily a specific amount that's calculated by the Department of Ed. So how does Ed make sense going forward? I mentioned one thing, and that would be maybe if we figured out a way to make all the interest instead of the 6.9 federal average, make it more like 3 in non-compounding. The Parent Plus loan program. On paper, looks really good, looks very profitable, but in reality, there are so many defaults in Parent Plus loans. Think about it. Most people who sign off on Parent Plus loans are midway or towards the end of their career, a parent or grandparent. So they don't have a 40-year, career in front of them, a runway to pay that loan back. And so you have an inordinate amount of defaults. You also had perhaps a poor understanding as to who is responsible for that loan. The student is not. It's the parent or grandparent who signed. And so in reality, those loans have a very high default rate and they're not profitable at all. So I think that program is going to go by the wayside. Maybe you'll have lower loan limits, perhaps, so that you'll have a little bit more privatizing of the loan. Public service, while it is a law, this particular government does not really want to encourage, I think, more people to go into government work. And the whole purpose of public service was, in fact, to encourage that. So going forward, you may have significant changes in public service, but you still have, it's a law, it's written into someone's master promissory note. So someone who's already in the program may, in fact, be grandfathered in some fashion or another. But going forward, we suspect that will change quite a bit. But we don't know. Our guess is as good as yours on that. Same thing with IBR. It is a law. It's written into everyone's master promissory note, but the terms could change. For instance, as of Friday, the Eighth Circuit, basically in expanding the injunction, so it didn't actually rule on anything. It's just an expansion of the injunction, but it stopped all loan forgiveness under ICR and pay. Well, there's a lot of folks who are in ICR and pay that might have forgiveness come up. Sorry, I have somebody outside doing something. And so that change, basically what's going to happen at the end of 20 and 25 years, if someone's on pay or they're on ICR, if the loans aren't forgiven, but you have that lower payment for 20, 25 years, what happens to the loan? Well, the argument is that it would be due right then, all at once. And ultimately, I mean, everyone has always believed that it would be forgiven, much like IBR, which has the forgiveness written into it. So we don't know what's going to happen with that. Usually the administration can, the agency, the Department of Ed can make those changes. There's a certain process they follow, a rulemaking process, committees. It usually takes a year and a half or so. We don't know what's going to happen there, but prior agency decisions may in fact be reversed. And so we've had significant agency decisions, some of which have actually been against what the United States Supreme Court has authorized with respect to forgiveness. Some have been extensions of programs, like for instance, with the disability program to eliminate the 3-year monitoring for income purposes. Some of those decisions may in fact be reversed. So we just have to wait and see on those and see which ones are going to survive. Now, I mentioned a moment ago the IDR recount or audit. This was something major that's gone on for the past couple of years. And importantly, everyone should know how you check it is you've got, it says IDR, it kind of cut off when I took a screenshot of that. But basically there's this, this green and white box. When you go on studentaid.gov, you can see here's how much time you have, here's the progress on the IDR, on the income driven, because that's one of the problems that we had. Folks didn't know how much time they'd accumulated or how much time they had remaining. If you call your servicer wouldn't know. That lengthy text file that you could download from the studentaid.gov site didn't say. So this calculator is very, very nice. It's very similar to the public service calculator, but they are two different things. They basically show here's how much time you have remaining. And when I say 20, 25 years, the distinction between that is if you have undergrad only loans, it's for 20 years. If it's grad loans, it's for 25 years. So this IDR program, this recount, was basically a decision by the Department of Education to allow for people with extended forbearances to ultimately get credit, including deferments and things, to ultimately get credit as if they'd made a payment. One of the reasons for that is because we had a lot of folks call their servicer, say something like, well, I'm having a hard time making my payment. What can I do? And instead of going through a public service analysis or an income-driven analysis, someone would just be placed on forbearance. And it appears that's a good, it appeared to have been a good choice because there's no paperwork required, it's a quick phone call, and there's zero payment then for 12 months. However, forbearance has a capitalization event that occurs at the end of the year where you have compounding interest. So you have interest due on interest as it's wrapped into the principal. So you have a higher loan balance every single year. And so we had balances grow and double or triple within 10 years or so. And so what the Biden administration wanted to do was correct some of that. Go ahead and give people credit if they had been on an extended forbearance, because perhaps they should have been on an income-driven plan instead. If someone called in and said, hey, I just lost my job, I can't make a payment, they would have been eligible for an income-driven payment of zero for 12 months until the next certification requirement a year from then. There's also issues where you had people consolidate and lose a prior loan history. That's a big problem. If you're trucking along and you have 7-8 years under the FFEL loans, repaying your loans, you consolidate to direct, you're wiping out that 7 or 8 year history. Yes, it's taken into account to what your loan balance is, but the years of payments are not taken into account. So when we had someone meet the deadline, which was June last summer, they would end up getting credit that was payments that had been made under a prior loan that was then consolidated. You had people making the wrong loan, making the wrong payments on the wrong loan types for public service. That was corrected through this IDR audit. A lot of things were really happening with the IDR audit. The last calculations that was done was in January. Now going forward, I understand as of Friday, the program was stayed. So what that means is anyone who's already received forgiveness, they're probably fine. But anyone who has, a year left or something like that, we don't really know what's going to happen with that because that's been stayed essentially. The SAVE program, here's some specifics on it. I won't go into this in detail because this is, again, the thing that was enjoined. It probably will never take effect, but we just have to wait and see what the lower court will rule on. Double consolidation. I mentioned earlier that we don't know exactly what's going to happen here, but the rule is still valid. Before I get into what double consolidation is, Jorge, do we have any questions that we can cover now for some of the stuff?
Yes, we do. We have a few in the chat. I'm just going to read them out loud for the benefit of the audience.
Okay.
So the first one is, you mentioned there's no statute of limitations for federal loans. That's the same student.
I mentioned there's no statute of limitations for federal loans, and then what was the question?
Does the same apply to private student loans?
No, private student loans are bound by a statute of limitations. The account agreement or note or whatnot will usually have a choice of forum clause, basically says what state law applies. If not, you've got wherever some of the regular rules with respect to borrowing, payment of statute of limitations and so forth. So no, the private have a statute of limitations.
There's another question about public service loan forgiveness, and basically the question is, if the borrower goes over the limit and then is approved for forgiveness, does the borrower get reimbursed for the overpayment amount?
In the past, yes, and they should. The reason why is because the payments are made on a direct loan. The U.S. government takes or is receiving the benefit of those payments. When refunds were not made was when someone had a FFEL loan because you're paying a private servicer for that. And so the government isn't going to give a refund for any overpayments. There's been a little fuzziness with the IDR recount because you can have someone making payments on a FFEL loan that ultimately, through the IDR recount, will receive forgiveness under the Public Service Loan Forgiveness Program, but maybe their payments had been made on a FFEL loan. That's a little touchy because, again, if the payment was made to a FFEL servicer, the U.S. government's not going to refund that. Most people don't fall within that, though. They generally are paying on a direct loan, and yes, the Department of Education does give a refund. Going forward, though, I don't really know what to expect on that, but technically, yes.
There's one more question, which is actually related to, I believe, your previous slide in regards to the IDR audit calculator. And the question is, where is the IDR audit calculator located, on the FedLoan website or the server, the Aid Advantage website?
It's on the studentaid.gov, which is the federal U.S. government site. If you look under loan details and such, you'll be able to see the repayment term there. Now, for anyone who's done a recent consolidation, it may not be up there yet, which is going to be a little problematic because since the program now was stayed as of Friday, we don't anticipate any further work being done to add that to the site. Anyone who sees that now, take a picture of it, take a screenshot of it, save any detail that you have for the IDR audit because, there's a lot of folks who consolidated their loans to get the benefits of this IDR recount. So if we don't see the IDR recount ending well, in other words, someone doesn't get the credit for that, maybe they relied on the assurances of the Department of Ed that they would get the credit of that. So we'll have to see. There'll probably be some class actions as a result. So can I go ahead and start with double consolidation then?
Let's get it moving. We do have a few other questions that came in. What I'm going to suggest for everybody is please use the Q&A feature if possible, because that way we can keep track of all these questions and make sure all of them are answered towards the end. So keep them coming. We'll try to make sure we address all of those towards the end. So go ahead, Christie.
Okay, so a lot of people have questions about double consolidation, and they also maybe don't understand what it is. So what it is Congress, which basically put into effect what some of these income-driven plans and so forth. Basically, they have said that for Parent Plus loans, the only income-driven plan that they are eligible for is ICR, income contingent repayment. The problem with ICR is that it's a fairly high payment. It's 20% of discretionary earnings versus repay was 10, IBR was 15. It's also a different calculation on expenses. So it's 100% of poverty level versus 150 under IBR, and even higher potentially under SAVE is going to be 225. So when you look at those calculations, what it means as a result is ICR is often a few hundred, if not 1,000 or more different. In other words, higher than the other income-driven plans. So if we had a client who, they would look at the different things, SAVE, IBR, repay, and ICR would always be much, much higher. In the past year or so, we've seen a lot of people with ICR payments in the thousands. They were equal to what a mortgage payment would be. But again, Congress has said that ICR is the only income-driven payment plan for Parent Plus loans. So what you had to do is if someone came to you with a Parent Plus loan, you had to consolidate those loans to be eligible for ICR. If you did not consolidate them, straight public service or straight Parent Plus loans were only eligible for the standard or extended plans, basically an amortizing payment, nothing to do with someone's income. So originally there was a software issue, or perhaps this loophole was in existence due to the language that was used, but you essentially had someone who could do a double consolidation and remove the characterization of it being a Parent Plus loan. Basically, you would take half the loans with one servicer, half the loans with another. That'd be the first consolidation. And then you would recombine them, and that would be the second consolidation. And then those loans were eligible for some of the other repayment programs, IBR, whatever you had. There was a specific rule that was passed July of 2023 that allowed for anyone who did a consolidation, as long as it was completed before July of 2025, they would then be eligible for these other income-driven plans. There was an indicator on the National Student Loan Database report that came out in August of 2023 that very clearly designated whether or not there was a Parent Plus loan contained within a consolidation. Or there was a lot of folks' fear that maybe that ended this double consolidation avenue of relief, but it really didn't. Maybe it was there as a tracker to ultimately be used when this July 2025 date came up. And so this rule and the place to find it essentially stated as long as you made a consolidation before July 1 of 2025, you could then be eligible potentially for some other income-driven plan. It's a rule. It's an agency rule. We don't know if that's going to survive. So while technically someone does have the ability to do this, we see some problems with that. I think that some of these agency decisions are going to be rewound in some fashion. And also right now, you have some issues because consolidation applications, currently we're unsure of whether someone can submit a paper application. You definitely cannot do one online. That was just shut down. And then the IDR, applications, the online was also shut down, but we are submitting paper applications still. I heard now, as of this morning, I mentioned that the paper application for the IDR plans was removed from the forms directory by the Department of Ed. So we're not sure if they're going to be processed. In the past month or so, we've been utilizing AidVantage. We understood that they were still processing consolidation applications, IDR applications, and we would send paper applications through AidVantage. We don't know for sure if paper applications are going to work. But right now, double consolidation is on the table. There's usually no harm in trying for it. Right now, though, if you are doing a consolidation, you want to be really leery of losing any prior IDR time for the notes that you've already accumulated, because the basically rules that allowed us to either redate, well, I don't want to get too much into the weeds here, but essentially we're now allowed to average. That has been stayed too. So right now it's very risky to consolidate. Very closely look at what you'd be losing potentially if the prior loan repayments were not counted for IDR purposes. If there was no IDR time before, no worries. But if there was, then I would be very leery about consolidating for the hopes of getting a double consolidation when we're not really sure if double consolidation is going to survive this. What we are seeing working is this total and permanent disability discharge. I call it TPD. Over COVID, we had a lot of folks in their 50s and 60s who they were not really eligible for SSD, but they found that they weren't able to work. And they have plenty of medical records that show this. And so the TPD process, disability discharge, is working. It was temporarily placed on hold, restarting in March. We have had a few approvals just recently. So they're processing them now, even though they had said that they restart in March. The disability servicer was Nelnet. It's been switched to the Department of Ed for now, but we like it. A couple reasons we like the TPD program. A physician can certify. They've expanded to where different types of physicians can certify now. There's no future paperwork requirement. For instance, let's say you have someone who they don't submit the paperwork for their SSD for Social Security disability. That is reversed. Their student loan would also be reversed or reinstated, I should say. If the disability was granted through a physician certification under the TPD program, the mere inability to not send in paperwork under SSD would not cause a reinstatement of federal student loans. And so I think the physician certification is clearer in that if the rules should change with SSD, then the student loans would not necessarily be reinstated like they would automatically be otherwise. If someone forgets to file the paperwork or gets lost or something, same thing. The federal student loan is still gone. There is a 3-year monitoring period. So after someone gets an approval letter that, yes, there's a physician that's certified that they're unable to work for a 5-year period or longer, and that's retroactive or prospective. Once they get that letter, there's a 3-year monitoring period. Now, it used to be that income was monitored. By a rule change that was already passed, it's not stayed. Essentially, there was no monitoring of that income. That's important because let's say you have someone who receives a pension or just any other kind of thing. I mean, they have some income coming into them. It has to be through their efforts and so forth. So maybe not pension, but the 3-year income monitoring, we don't know if that rule may not be basically changed, or I don't know if I should say reinstated, but maybe the income monitoring would come back into effect. But right now there is no income monitoring. The approval process is very quick. It's 30 to 90 days. I generally will say 90, but it's usually faster than that. And so not only is it immediate, but there's also no ramifications if somebody doesn't stay on SSD through whatever means they have available to do that. We like what we see. We don't know if things might change after the Department of Ed takes control of that program, or what's going to happen. It used to be that all the applications went to Nelnet, and I understand that that is changing, and so we don't know what to expect there. But for the moment, that's been one of our favorite programs. And I shouldn't say that it's tax-free, but it's potentially tax-free. The program itself allowed for discharges to be tax-free, and the funding for that ended December 31 of 2025, so the end of this year. Coincidentally, that's going to end when the student loan forgiveness waiver of taxable event also through one of the job, I think Americans Rescue Program, one of the job stimulus bills early in COVID, essentially said that, hey, any federal or private student loan forgiveness that occurs before December 31 of 2025 will then be tax-free. Coincidentally, it's the same date, but it's a different law that provided that. So we hope that that will be refunded and will continue to be tax-free. But with the changes going on right now and the funding of government, we don't really know what's going to happen there. This program here, allowing for the DOJ and U.S. Department of Ed to talk and communicate about whether someone has shown an undue hardship in bankruptcy. Again, 85% of the loans appeared to be dischargeable or discharged in the past few months. This was put into place November 17 of 2022. But at the moment, while there hasn't been an official pause or a court pause, we understand the Department of Ed and Department of Justice are not progressing on those applications at the moment. That's fairly recent. We had been filing them up through last month or so. One of the reasons why I don't know if this program is going to survive is it even has in there. It's not intended to and does not create any rights enforceable at law by any party in any manner. I mean, that's kind of perfect to unwind if you didn't want to do that. So even though this program to allow for the attestation process through an adversary proceeding to get rid of a federal student loan in bankruptcy, even though it was promulgated initially under President Trump's first term, we don't expect for that to be, well, of course he's going to renew it for this term. We don't know. And in fact, I personally think it's probably going to go by the wayside. That being said, some of the recourse in bankruptcy is really working. This was some information on the attestation case or cases that we can do. The important to note for this, for pre-filing purposes, if you have someone who's about to file bankruptcy and they want to try to show an undue hardship, often it's best to consolidate so that they have a direct loan before filing. Now, again, you want to make sure they aren't giving any prior IDR time up, but a direct loan is governed by this attestation process. And if it is left alone or redone in some fashion as to who's controlling it, but if essentially it's the same process, then having a direct loan and being eligible for that, you've got a good potential of having the loans discharged. So I do think that you want to try to maybe consolidate to a direct loan to be eligible for that. The important part about the adversarial process is nothing's really changed for private loans. Over the years, when I first started doing student loan work, I initially was working for ECMC, USA Funds, some of the federal servicers, and was opposing, right around the state of Florida, was opposing dischargeable or discharge cases for undue hardship. But when I kind of switched sides and started to do this only for our debtor practice, we focused on private student loans because the Bruner standard is very hard to meet to show an undue hardship, particularly with a gig economy, because it's very hard to show a negative, very hard to show my client cannot achieve a standard of living, a minimal standard of living while making a student loan payment for the next 20 years or so. But in private student loan world, there were different arguments. You had undue hardship, yes, but you also had the argument that maybe these weren't really student loans to begin with. Maybe they were non-qualified education loans. You had a lot of folks who would receive a check and they weren't school certified. They didn't come from the school. They had high rates of interest. They had co-borrowers, had all the earmarks of what would be a private loan. It's just that they were called student loans. But in fact, they were often used and marketed for doing other things, paying off debts or whatnot. And so, and some of the student loans, like for instance, a bar study loan, it was not intended to be a student loan. It wasn't covering education. It was covering someone's living expenses while they studied for the bar. So many of those loans are non-qualified education loans, loans that went to schools that were not eligible for Title IV funding, Caribbean medical schools. A lot of the schools down there are eligible only for private loans or self-funding by the family, as opposed to a federal program. And so we're very successful in the last 10, 20 years getting private student loan discharges for all kinds of vocational schools. Sometimes the borrower, the person who signed, is not a dependent. So we argued non-dependent relationships. There were lots of different areas. Now, those all still exist, and the law it has only gotten better with respect to private student loan discharges. And so if you have a private student loan, an adversary process, it's probably maybe a good idea. These tuition answer loans, again, they're direct to consumer loans. You basically can use some information online to try to show what the cost of attendance is at that school, including room and board. I have a site there at the bottom that you can go to that helps with that. But essentially, you show that this loan was above and beyond the cost of attendance, and it was a non-qualified education loan. You don't even get to undue hardship. It becomes an unsecured loan, just like a credit card. So it's paid into bankruptcy as a credit card would be paid. There's been a lot of older case law, I should say, that and servicers will regularly say, well, you can't bankrupt a student loan. Yes, you can if it's the correct argument to, have it discharged in bankruptcy. But you had a lot of servicers who would argue that you can't bankrupt a student loan. There was class actions regarding that. Woodward is one of them. Essentially, no party has to file an adversary proceeding. The lender doesn't have to file, and the borrower doesn't have to file. But if you file a bankruptcy in the past 10 years and you put in there that you have a student loan, what happens to that student loan? Well, if it's a federal student loan, it rides through the bankruptcy. It accrues interest, you still owe it, and so forth. But a private student loan, was it discharged? Was it not? The confirmation orders or the discharge orders typically don't have a list of what's going on. And so you're guessing. And so either side can file an adversary proceeding and kind of get a comfort order. This debt exists or this debt doesn't exist, or there's a settlement agreement as to how much I'm paying, maybe a reduction in interest or amounts or so forth. So we look at all these tools. We look at what we can do outside of bankruptcy. We look at what we can do inside bankruptcy, whether it's private or federal, to basically try to reduce the amount of debt to something that's sustainable and affordable to repay so that someone can still start a family, buy a house, start a business, whatever they want to do. And if they have other debt, sometimes the options in bankruptcy work hand in hand with that. If they don't have other debt, then maybe the options outside of bankruptcy might be better for them. In the past couple of years, we've had a lot of options outside of bankruptcy. So we haven't dealt with bankruptcy a whole lot, even though we have a lot of bankruptcy work otherwise with our firm. Going forward, though, if some of these programs are either uncertain or they go by the wayside, we may see that some of the remedies in bankruptcy will come back into place. For instance, curing a default, something as simple as that. I don't know if you knew this, but with a federal student loan, you cannot just catch up. If you miss a car payment, 3-4 car payments, as long as the car's not repoed, you can usually catch up and basically have that loan reinstated. In the federal world, the administrative remedy is this. If you're behind, if you're in default, which they have a lengthy time period, it's 270 days or 9 months of missed payments, delinquency status before a loan becomes in default. So it doesn't happen the first day the missed payment occurs, but it does happen. During COVID, we had a lot of non-communication, miscommunication, address changes, whatnot. So we have people who are coming out of the woodwork now that their loans have went into default and they didn't even know about it. So how do you cure that default? Well, if they have a consolidation loan already, direct consolidation loan, we can't consolidate it again, not unless we have some other loan to put it with. If they've done a rehab in the past 10 years, we usually cannot rehab or really rehabilitate the loan again. If they haven't, then of course we can do that. The Fresh Start Initiative temporarily was fantastic. It allowed for very easy reinstatement of the loans. That's gone now too, as of I think October 2 of 2023, if I remember right. It's been gone now for almost a couple of years. And so if we have someone who's accidentally defaulted in the last few years, if we can't cure that default through either a consolidation or a rehab, those are what I call the 2 get out of jail cards. There's no other way to just catch up on that loan. And so we may have to do a bankruptcy, a Chapter 13 plan to cure the default. We used to do that. We didn't have to do that in recent days, but now we may have to go back to that. You can object to Chapter 13 proofs of claims on either the documents that the lender provides, particularly with private loans, or the interest, the accumulation of interest, how repayment records are kept and so forth. Those objections to Chapter 13 proofs of claims will ride through the case and be there if the bankruptcy is discharged, be there for future. So for instance, if you have a objection that is granted, there's no response or whatnot, you have an order that states that this loan either doesn't exist or it's reduced, then you have a discharge in the bankruptcy. Now, a year later, you're back in state court and a private lender sues on a private student loan. You now have a order from a bankruptcy judge that says, no, this was adjudicated in the bankruptcy. Here's what I owe. And so even just simple objections to proof of claims might be good, might be on a statute of limitations basis. For private student loans, I think it's getting a little late, it's a little long in the tooth now, but there's tax-free forgiveness through the end of this year. Back when we had 2-3 years, we emphasized that a lot because there's a lot of people who would be on a 3-year plan. They could maybe reduce that to 2 years and be done with the tax issue. What I mean by that is, let's say you settle a private student loan for 30 cents on the dollar. Well, the other 70 cents on the dollar means that you're going to get a 1099 on that. And you're going to owe as if you had another job paying that 70% figure that year. Well, that's waived as long as the forgiveness occurs before the end of this year. Now we've only got 6 months left, but if you have a client who has a private student loan, federal as well, but this is really more for private, if you can settle and get it paid through the end of this year, maybe that's something to strive for. We frequently will stick them in bankruptcy, obtain a lower interest rate, lower balance, and so forth by either arguing an undue hardship or a non-qualified education loan. We use consumer laws. Here in Florida, we have the FCCPA, which is similar to the FDCPA. Inaccurate reporting on FCRA, we use that. We use all these things to either sometimes get a settlement that's outside the box or bump it up in terms of escalating to a different decision maker or higher decision maker, just something to try to get an affordable payment going forward. So it's going to take a little longer to try to figure out what to do for a particular client going forward, in part because some of these programs are being dismantled or are ending or we're uncertain with them. So we're taking a little bit more time to make sure that we have the best path going forward and we're not hurting that client. Similar to the medical world, do no harm. We want to make sure, first of all, that if we do a consolidation, are we ending any IDR credit that they already have? Maybe they need to stay in the loan that they have and finish out the plan with that loan if we're uncertain as to what's going to go forward. Maybe the bankruptcy orders. Bankruptcy orders are awesome because regardless of who's in control, the order has the finality and you have a document that shows here's my payment plan going forward. I can't tell you the number of clients who come to us that just want to know what they owe and have a plan. They don't care that they owe something. They just don't want it to keep flip-flopping all over the place. And that's huge to have an order that says that. And so here's the Ombudsman Office. Right now, a lot of their staff has been laid off. In the past, it has been the best way to get an answer to a more complicated question. I did go ahead and place their phone number and the online information on filing a case. That's how they answer a question. You basically file a case and they will reinstate the question as well as provide documentation and answering it. Usually some wonderful information is available through the Ombudsman Office. It's a free process. We look at it as kind of an appeals department of the Department of Ed. We don't know its role going forward, though. I understand that much of the staff, if not most or all of the staff, has been released now. So, going forward, we're not sure what to expect there. Here is some other information. The NCLC has some awesome treatises. You can access them digitally as well. Student Loan Borrower Assistance Org, there's lots of information there. Basically, pretty much anything you need to know. We have about three more questions. I want to, minutes. I want to see if we have any other questions, Jorge, before we close out.
Yes, we do. I've been dropping some of the CLE info here just in case somebody needed to jump off, but let me go ahead and pull up the questions that we have right here. So, okay. So the first question is please correct me if I'm wrong, you can be in an IDR pay plan and still do public service loan forgiveness, right? That is what I have been doing, but I just noticed that in the student aid website, IDR calculator, it says that I'm like 10 years away, but I am at 103 qualifying payments for public service loan forgiveness. Can both be true?
Yeah, so essentially both can be true. The way it works is that the calculator looks at a broad picture. It doesn't change with respect to if a consolidation is done, if someone's in public service. Sometimes the figures don't match. But yes, as long as you're in an income-driven plan and you complete 120 payments, including through the IDR recount, then you would receive the public student loan discharge. You can also use any 10-year standard payments if for some reason the income-driven plan is too high for you for that year, you're not eligible or something like that, you can do the 10-year standard as well. But yes, just continue to certify your employment and fill out the application for discharge. The first page in the application will say, I've already paid my 120 payments. I'd like for my loans to be placed in forbearance while it's being reviewed. You can do that, but you still have to work for the agency. So don't resign or retire or move elsewhere until you have your loans discharged.
All right. Now, next question is related to tax implications. So let's say Bob is under an income-driven repayment plan and he gets public service forgiveness after 20 years. What are the tax implications after those 20 years of taxes?
Okay, so a little mix there. If it's 10 years and it's a public service student loan discharge, it's tax-free. That's one of the requirements of public service loan forgiveness. If it is in fact non-public service, so you're working for a private company, then it's 20 years if you're in undergrad loans, 25 if you're grad loans, and it's potentially a taxable event. Congress has written the rules thus that it is a taxable event. It would have to be changed so that it was not otherwise. We refer to that as a tax bomb, and I think that we will have a significant taxable event that you'll want to plan for if you are not working public service.
Okay, and one more question. If an individual was on the income-driven plan before switching to the SAVE program, once the SAVE program ends, will the plan automatically go back to the prior plan of income-driven?
Well, people who were on repay would automatically be placed into SAVE, and then they were on SAVE for a few months until they were placed into like a SAVE forbearance. And so what's going to happen if SAVE is not in place? We don't know exactly. I suspect that folks will be allowed the opportunity to file a new income-driven plan application. Maybe if repay is reinstated, they'll automatically go back into repay. I'm not hearing that repay will likely survive either, though. So it's more likely that someone will have to fill out a new application to go into an existing IDR program, whatever ones are still left, and importantly, certify their income as of that date.
Okay, and I do see somebody with their hand up, Anne Marie Wilburn. I'm not sure if this was on purpose or not, but think I can try to have you come off mute, but I'm not sure if this was inadvertent or not. So if you feel free to drop your question in the chat just in case. I know we're a little bit over time. I want to read the CLE code out loud just in case. It is 2501015N. I'll make that code is going to be on the YouTube description. It's going to be on the email that will go out automatically. And it's here in the chat just in case. So let's see, we may have one more question here. Under public service loan forgiveness, can you make multiple payments at once to qualify once the 10 years in public service is met?
No, you cannot pay ahead like that. It's called pay ahead status. And in fact, that was one of the biggest problems of public service was that people would pay ahead when they were going to be on vacation or not working over the summer, and it caused there not to be a payment due. So therefore, they wouldn't get credit for that next month's payment. So you can't pay, has to be each month.
All right. I don't see any other questions. So I want to thank you, Christie, for this amazing presentation. And thank you, everybody that attended the webinar today. We hope you found this session helpful. A quick shout out to the public interest law section, in particular the consumer and tenant work group. They brought up the idea and they helped me recruit Christie to bring this amazing training. So Len, I believe you're here. Thank you. And Laura, you're great. So this is why you should join PILS. You should take a look at it and join these amazing work groups. And with that said, quick reminder again, make sure to join all these listservs. I'm going to include and subscribe to listservs and blogs. I'm going to include Christie's website, her YouTube channel, her blog. All of it's going to be there. Take a look at NCLC. They have some pretty great listservs when it comes to student loans as well. They're pretty active. I know NACA has some information too on student loans. So as Christie said during the beginning, this just keeps changing. We may get some updates by the time we end this webinar, right? So just keep up to date with these resources. And thank you again, Christie. Any final thoughts or comments or questions?
Really just, you might want to think about doing a public service specific one, but wait a few months. Because right now we're not seeing that the buyback provisions are working, but public service is working. But we're going to see some changes. So I would maybe do one specifically for that with your group. I think you have a lot of interest with that, but I think it's too early and be a waste of everyone's time right now. So maybe May or June, possibly.
Yeah, we'll definitely add it to the calendar and we'll follow up and see where we're at back there. We did have one more question pop up. Just make sure that I want to make sure we address it. So the question is, after the 20 to 25 years forgiven under the normal income-driven repayment plan, is the balance given under the 1099 need to pay all in 1 year, or is there like a payment plan to spread out that
Well,
payment?
I don't do IRS work, but typically, if you do not have the ability to pay all at once, I guess the IRS does have payment plans. They have offer and compromises. I don't do IRS work to know specifically, but you're looking at your solvency at the time of that discharge. So for planning purposes, if you are insolvent, in other words, if you have liabilities that exceed your assets or limited solvency, you may find that the taxes are not as much as you think. So that you'll know roughly when that year is going to be. And so you might want to plan for that eventuality. You might also want to push it off. I mean, you could use a forbearance, a deferment, or a different student loan repayment and then finish your last month or two or so of the IDR in a time period that you would expect to have more insolvency. So think about that planning if Congress does not change the law between now and then, which it probably will not, but we don't know.
I know we're a bit over time, so if anybody has any questions that we were not able to get to, feel free to email them to me, and I'll share those with Christy, and we'll try to get the answers to everybody. So thank you again, Christy, for this amazing presentation, and everybody for attending, and we look forward for everybody to keep attending these great events. Thanks.
Appreciate everyone's time. Have a great day, everybody. All right, bye-bye.